Okay. Well, I think that's great. We're going to make a start. So welcome everyone, and thanks for joining us this morning. This is the first in our practical people management series of webinars. I'm Ed Hussey, and I'm here with Karen Gibb and Claire Stevens. We're all in the people solutions team at Menzies, providing outsourced HR services and consultancy. So I think we know most of the people on the call, but there are a couple I think who we maybe haven't met before. So thanks very much, and it's lovely to have you with us. Our first of these sessions is on managing disciplinary procedures, and we're going to cover this in an informal, practical way. We're not covering all of the procedural details, but we're highlighting the key issues and things that typically happen, and what our experience has basically taught us over the many years that we've spent handling these kinds of issues. There are certain themes and typical things that crop up that we thought was worth sharing, and also, of course, an opportunity to for you to ask any specific questions that you've got. You'll see, for those of you that have joined us before, we're using a different webinar format today. This is mainly so that we can record the result and publish it on the employers community. But you can still join in, as I said, so please do either raise your hand if you have a question to ask. We very much still want this to be interactive. Raise your hand and we'll bring you in. I think we can unmute you and you can ask your question, or if you'd rather pop it in the chat function, then put it in the chat, and Claire's going to be looking out and coordinating things so that we make sure that we can bring in questions and comments as and when they come up. So please do join in on that basis. So, quick introduction. I mean, disciplinary rules and procedures. We have rules to set out the ways employees should or should not behave. And we have procedures to ensure that these issues are dealt with in both a fair and effective way. And those procedures should uphold the principles of natural justice for employees, whilst ensuring that the employer has a route to be able to deal with issues that crop up. So that's why we have the procedures. And a quick note just on contracts and policies, because all employees must now have a written statement of terms and conditions of employment from day one. It used to be that you didn't have to provide it for day one. You do now have to, and that must contain disciplinary rules and procedures, or refer the employees to a document that's easily accessible that sets out the arrangements, for example, in their handbook. And your policy is very, very likely to follow the ACAS Code of Practice on disciplinary and grievance procedures, which sets out at the beginning those kind of principles of natural justice that I just mentioned. Disciplinary issues come in all shapes and sizes, of course, but what I always find useful is to use these principles as a touchstone, because you can adapt your approach according to the circumstances of each case. But I think if you bear in mind the key principles and you stick to those, then you're not going to go far wrong. And those are that, first, you raise and deal with issues promptly. Don't leave them too long before you deal with them. That you act consistently. That you carry out the necessary and reasonable investigation, which will vary according to the circumstances. That you inform employees of the nature of the issue and give them an opportunity to put their case. That you allow employees to be accompanied at any formal disciplinary hearing, and that you allow them the right of appeal. We're going to unpick some of those issues as we carry on chatting, but those are some of the key touchstones, I think, that it's important to remember whenever particularly if you're first faced with a particular scenario where you're thinking about, what's the appropriate, how do I need to use my procedure and adapt it for this particular circumstance. Make sure that you're covering all those bases to start with. Now, obviously, many disciplinary issues can be resolved informally with a quiet word, and that's always the preferred option if the circumstances permit. Sometimes a quiet word isn't always appropriate if it's a very serious matter, but minor issues, obviously, hopefully can be dealt with informally. But what we're going to talk about this morning is where informal resolution isn't possible, or where it's been tried and it hasn't worked, and there's been repetition of events, and therefore a disciplinary procedure will be used as the way to deal with the issue. So it's quite a big topic, and Karen's going to take us through the first parts of it. We're going to kind of deal with it more or less in order. So I'll hand over to Karen and she'll take it from there.
Okay, thanks, Ed. I'm going to firstly just put a couple of parameters around it, because as you say, not only do employees do various things and behave in various ways that you may have to deal with, but obviously there are different approaches to your disciplinary processes. So we will deal primarily today with conduct, so employees' behaviour. You can use these processes for performance, for poor performance. We often recommend that you have a separate process for that, which is similar, but is called capability. If you don't have one of those, the disciplinary process can work for performance. We just adjust it slightly. But our topic today is really dealing with conduct issues. The other thing is that you may deal with poor attendance under this policy, or unreliable attendance. But if you were dealing with sickness issues, particularly anything to do with a long-term health condition, then we wouldn't deal with that under this procedure. So I'm just going to set that one to one side, and that will be a topic for another day. We're also basing today's conversation on employees who've been with you more than 2 years. So there are certain rights and entitlements and legalities that go with 2 years service. And part of that is requiring you to follow a full procedure, and that's essentially what we'll talk about today. So that just puts a couple of parameters around what we're talking about. I'm going to cover off with, we're covering each of the stages, so I'm going to start with the investigation. I'm then going to talk a little bit about holding a disciplinary hearing. We're going to talk about the decision that comes out of that, so what the appropriate warning might be. We're going to touch very briefly on dismissal and appeals. So getting started with the investigation, I'm often asked, who can investigate? So primarily the first stage is to say, right, I've got a situation here. I need to find out what's happened. The best person to investigate is firstly not the person who's going to end up holding the disciplinary hearing. If you can in your organisation separate that out, then that is much better. And your investigator will do their job and report to the person who's going to hold the hearing and provide them with the information they need. That's not always possible in a small organisation. You may not have that many people, and you will have to work around that, but certainly that's the ideal. And an investigating person should be somebody who is familiar enough with the circumstances in the workplace to understand what's going to come out of the meeting, particularly if there's technical aspects to it. They should be impartial and not involved in the incident. They should be able to ask questions and conduct a good interview. And they should be able to summarise for you in writing what their findings are. So that's the kind of person that you want. And you do want a good report writer, and you want somebody who's able to question and to find answers for you. So having established that you're going to hold the investigation, just to say you need to size and scope it around the circumstances. It needs to be a reasonable investigation for the circumstances. Obviously, the more complex and the more serious the situation, then the wider the scope of that investigation will go. You primarily in that stage really need to make sure you've asked the employee for an explanation. You can call employees to an investigation meeting at your request. It doesn't need notice. It doesn't need to be in writing. It doesn't need to have a companion. You basically need to gather the facts and allow them to put forward the situation as quickly as possible. If they explain their actions, and let's face it, sometimes that happens, then essentially that might be the end of it, or you may decide to deal with it informally. You may uncover some other circumstances that you need to go away and work on. But if a disciplinary is warranted for this individual, then you'll essentially need to make the decision about how serious you view that, and that may mean that you need to suspend them from the workplace. Suspension means that you are essentially removing them from their responsibilities. You're probably going to ask them to remain at home while the investigation is completed. It's not a penalty. It is meant for the purposes of conducting the investigation, but it will usually be in the most serious cases. So we're talking something where potentially they could be dismissed. And if you're suspending, you will do that formally and in writing with the employee. Either way, your investigator will come back to you with the report. You will decide what the serious concerns are that you have, and you will write to the employee and invite them to a disciplinary meeting. You'll provide them with the evidence from the investigation in advance, so that they have that available. And your investigator will have ensured they've investigated it in an impartial way. They'll always take account of confidentiality, and the whole situation will have been handled as quickly, promptly and professionally as possible. So you're then inviting the person to essentially to the disciplinary meeting as the next stage. I'll touch quickly. They're all the things I'd like you to do. So let me just jump in and say a few things not to do. So I don't think, it's fairly obvious if you fail to gather the evidence, if you fail to provide it in advance to the employee, if during the investigation they never get the chance to give their side of the story, if you don't properly inform the witnesses, if you have them, that they'll need to give a statement and they'll need to potentially attend the disciplinary hearing, they may be unwilling to take part, or you may not have taken account of the fact that they need their anonymity or their confidentiality protected, and you will have had to have put all that in place at the investigation stage. Also, don't ignore key witnesses just because it doesn't support the case that you have. Investigating is all about finding all of the circumstances. I think there's some of the pitfalls. I think as well the other. Sorry, Ed, after you.
Sorry, I was going to ask you. I know that, and I think this might kind of hark back to the old days when the procedures weren't quite so full, where people will often say to me, "Well, can't I just issue a written warning?" You know, people. I think there's often a sense that, you know, if something's happened, you know, it's pretty open and shut. It's pretty obvious what took place. Can I not just get someone in?
Yeah.
Tell them I'm giving them a warning, confirm it in writing, and will that be valid? You know, will that stand? That's quite a common one, isn't it?
Yeah, and I think, you know, that's a natural question to ask. You asked me to go all through the investigation. It's blooming obvious what happened, so I just want to issue the warning now. Yeah. Well, that's one of the things not to do at the investigation stage. So we want you to close off the investigation. We want you to invite the employee properly to a disciplinary hearing, and they know that that is the disciplinary hearing. And then they come along to that prepared with all the things I'm going to tell you in a minute. After that meeting, our advice, Ed, is then, yes, you've been through that process. If at the end of the disciplinary meeting you want to issue the warning, then it can be formal, it can be on the record, you've done all the things you need to do. But I think the people asking you the question before that, they're not going to have a valid warning on the file because they never held the meeting.
Yeah. And they may also not have done a reasonable investigation. I mean, it might be that people want to jump straight from something's just happened through to let's get them in the office and give them a warning.
Yeah.
Now and I think this is often also where the thing about a reasonable investigation comes in, because, you know, we've both handled some really big disciplinary cases involving, say, something like potential fraud or something like that, where there's lots of people involved. It's quite complicated. You know, there's a lot of paperwork and analysis to look at. there are lots of people to be interviewed as witnesses. That is a big investigation. Then there are minor things that happen, and then, I mean, a classic one is, someone's persistently late.
Yeah.
So so I think the question is, what does a reasonable investigation look like in one of those slightly more open and shut cases? But I think it's still important to really kind of segment your process into investigation, invitation to a disciplinary meeting, hold a disciplinary meeting, even if the investigation bit could be quite quick.
Yeah, I agree. Yeah.
You think?
And I think, yeah, I agree. And the other thing is, let's take that example of somebody who's persistently late. All right, they're late because you see them walking in every day. And you may very quickly move to the stage where you invite them to a formal meeting to discuss that. But don't forget to gather the data about their lateness. So don't sit down at the meeting without being able to give some factual data that says, over the last month, you have been late on 10 occasions on these dates by at least 20 minutes a time, which adds up to lost working time of X. Because you'll want to be really specific. So that doesn't need a huge investigation at that stage, but you do need to have that data. And perhaps you need to have asked the employee the question beforehand as to whether they have a reasonable explanation. And if they don't, you end up at the disciplinary meeting. And factual data like that just makes the conversation so much easier to have, because, then you'll say, this is the amount of lost working time we have, but you need the information.
There's nothing, well, there are a few things, but it's quite that are more excruciating. But it's quite excruciating to be sitting in a disciplinary hearing and for allegations to be made on the table, where the question comes from the other side. Well, where's the evidence for that? I mean, if you haven't got it, it's not a situation you really want to be in.
No. Or you get that dreaded thing where they say, but I told so-and-so on the day and they said it was okay.
Yeah.
And then you unwind this whole other communication channel that took place. And anyway.
And actually, that's just while we're on investigation, that also happens, doesn't it? Actually, that I've been in those situations where an investigation's been done, you're holding a disciplinary hearing, you're going through it, and in the process of discussing it at the disciplinary hearing, a whole new aspect to it kind of comes up. I mean, that example you just gave, for example, oh, well, I spoke to such and such and such and such. Now, obviously, during the investigation, hopefully all of those channels have been unearthed and investigated. But sometimes you could get into a hearing and someone surprises you with something that you didn't know before and wasn't included in the investigation. And I've known it where hearings have been postponed or adjourned in order, and the investigating officers sent off to do some more investigating and then come back, and you reconvene when those facts have been more thoroughly investigated. I mean, I think we're gonna, as we talk through, we'll go more into the meeting. I think people get very focused on a disciplinary meeting or a hearing, whatever you want to call it, but actually sometimes the fundamental mistakes were made even before you get there. So that investigation stage, that is really important. You really think about that. And if you are then the manager that has to hold that disciplinary meeting, you are then responsible for the evidence that you bring to that meeting. So if you weren't happy with the investigation, or you feel your information is light, go back and check again before you sit in front of the employee, and make sure you've really got what you need. So I think, really stage. That's a really good point. And particularly if you're looking at a potential dismissal, the investigation of that is going to be absolutely crucial, I guess, because there's more of a chance you might end up, in a tribunal or with a claim being made against you, if you're dismissing someone. And I know, I mean, I've sat in tribunals where actually the person who did the investigation is kind of the key one of the key witness in terms of how they investigated it and what they found out.
Yeah.
Yeah.
And I agree. Shortcuts made at that stage then end up with you feeling very, very uncomfortable later on when you need to justify it.
Okay.
I'm going to canter on and talk about the actual disciplinary meeting a little bit then, Ed, and I'll hand back to you in a minute.
Okay.
I've got some kind of what to do's when you get to the meeting. First of all, really to say the purpose of the meeting is to bring the employee in with the full understanding as to the purpose of the meeting, and pre-armed with the information as to the concerns about their conduct. They arrive fully informed, and you then hold a conversation around the circumstances. You have the opportunity to ask questions, and you as the disciplining manager will have a really full understanding as to the circumstances. You're going to make a decision at the end of this whether they deserve to be warned or even to lose their job. So the meeting isn't to pull them in and just dish out the warning. In fact, we're going to ask you specifically not to do that. We're going to ask you to bring them in, ask questions, fully understand, allow them to state their circumstances, bring any evidence that they want, and from that discussion you will then consider and make your decision. That's the purpose of the meeting. So having said that, just to backtrack, you concluded your investigation, you were really happy with the information, you wanted to hold a formal disciplinary, that was the right route to go. You invited the employee to the meeting and gave them at least 48 hours notice, is always our recommendation. And you gave them the information in advance that you intended to discuss with them. And they got all that in writing. Part of that invite will tell them about bringing a companion. We get lots of questions about companions. That is specified in the guidance, and it is very specific. It is a workplace companion, or it is their trade union representative. But lots of businesses say we don't recognise trade unions. That actually doesn't matter. It is the employee's right to bring a trade union representative if they are a member. They will be paying their subs, they will have a membership, and their trade union representative can come with them. You'll often call us to talk about that because that will kind of seem a little bit worrying, and obviously we're very happy to help and give support. A trade union representative will always be absolutely nailed on with the procedure. It's what they do in, day out, so you will need to get that right. But I would say they are highly professional, they are very well trained, they are very supportive in these procedures, and it isn't anything to refuse or to be overly concerned about. You will often find they will be very helpful in getting through the procedure and getting a reasonable outcome. So nothing to be worried about. A companion is not a lawyer, it is not their lawyer, their solicitor, it is not their mum. It is not anybody else who they'd like to bring from the outside, except do take account of disabilities, any special needs, take account of a young person, anybody who will struggle with the information you're presenting or with representing themselves, and flex that companion rule accordingly. So I have had family members attend with somebody. Equally, that's quite challenging, to be honest, when it's a family member, but you either will maybe have a responsibility, say for instance if they need somebody to help them communicate, but equally they may just not be in an emotional state to cope with the circumstances, and there may be nobody at work that they want with them. So you might have to be flexible. Bottom line though is it's a workplace companion.
I do agree, sorry Karen, just to jump in there, I do agree though that it's a really good idea to not be too black and white about that. I can certainly think of occasions where we've allowed either a friend or a family member in because I'm in a particular circumstance I'm thinking of relatively recently with a client where the workplace wasn't very big, so actually they didn't have a lot of options for workplace colleagues to come, and actually the nature of the issue was they didn't really want to discuss it with workplace colleagues. It was clear though that it was going to be a very difficult meeting without that person being supported. I mean, some people say, no, I'm fine. I don't need a colleague. I don't need a companion. Thank you very much. And you think, well, yeah, that's so that they're making a very clear decision and they're confident in that. That's fine. Other people clearly would like to be supported, but there's just no one available of the right type, of the right, you know. And I think in those circumstances, you do well to be as flexible as you can. So I know, for example, in this particular case I was mentioning, we did allow someone to bring their daughter with them, because actually on balance we felt that that the person needed some kind of support. They needed someone to be there to pay attention to what was going on so that they could talk to them about it afterwards, you know, someone else in the room that could then and the other, I think the mindset is, you know, if you're getting your process right, and if you're handling the meeting correctly, why wouldn't you want someone, you know, why wouldn't you really want someone in there? So I think just to blithely say, no, I'm sorry, and to refuse in all circumstances can be a bit short-sighted. Now, obviously, when the moment comes and the person walks in with their companion, you are slightly nervous because you don't really know what you're going to get. But of course, we do make it clear in those circumstances what the role of a companion is.
True.
You know, that they're unable, that, you know, they're not there to speak on behalf of the person they're accompanying, and so, you know, they're not there to answer questions on their behalf. They're there to support, consult, you know, listen, those kind of things. So I think it's as well to just think about that, you know, circumstances.
Yeah, I agree.
Did I see a hand go up, or has it gone down again? Oh no, I think it's gone down again. Did anyone have a question on that before we move on? No. Okay.
All right.
Good.
Yeah, I'll just talk a little bit about the meeting. Quite a daunting experience if you haven't done it before. Essentially, you are, as I say, you're going to be with the employee. They're going to potentially have their companion with them. You will both have the relevant evidence that you intend to look at. You will have asked the employee if they've got any evidence that they wish to raise. You will have asked them to provide that in advance. That doesn't stop them bringing it on the day, I can assure you, but there we go. You will have asked for it in advance. And essentially you go through a very reasonable process of looking at the evidence and explaining it, making sure the employee understands what the concerns are about their conduct and asking them for an explanation. You may be, as Ed has said, in a relatively complex procedure where witnesses come and say what their involvement was and what they saw of the circumstances. But one way or another, there will be information that will come out in that meeting, and you will essentially listen and take account of it. You're not jumping to judgments at that stage, but you can certainly robustly question circumstances. I have been in disciplinary situations where we were fairly certain that the employee was telling an out-and-out lie. And although we didn't necessarily use that wording, we were fairly straight in our questioning as to the circumstances, so that, you know, the plot started to unravel a little bit. So it is a situation where you will be using your judgment to find the information that you need to know. The employee may ask you some awkward questions. You know, if you've not got, I don't know, suitable processes and procedures in place for your employee to do their job properly, then expect that to come back. And in reaching your decision whether a warning is necessary, you'll have to take account of anything that you as the manager or the employer hasn't put in place. So, you know, that's really what that meeting is all about. Because I find it difficult to talk and write and listen all at the same time, I would always want somebody with me at a disciplinary hearing So it's great if you have a note taker. It's even better if you have somebody who is there not only to take the notes, but to help you to go through the information, so a fellow manager. Don't completely overload the panel on your side. So, you know, the very most you'll end up with is an accompanying another manager and a note taker. If the manager can do both for you, then that's even better. You might have an HR person instead of another manager, but have someone else who is listening, note taking and helping you, because otherwise it's a lot of information to assimilate and to manage. And essentially take everything into account, close the meeting when both sides feel they've put forward everything they need to, and don't, except in the very simplest of circumstances, I would say don't make your judgment and issue your decision then. Step away, consider, tell the employee what communication channel you will use to come back to them with your decision, but take a pause, think it through and go back to them with that decision. Your decision will be in writing anyway, even though you may tell them verbally first, but we would always say step away from the meeting to really consider the information you've got, and then you'll reach that decision. I'm just going to let Ed pick up on a couple of things from that, if you would, Ed.
Yeah, sure. I mean, we've mentioned already, you know, don't be shy about postponing the meeting. If you need to go back and if you need to backtrack a bit and go and find out something else, then or if someone comes along and throws a spanner in the works, then postpone the meeting. You gave the example there, Karen, of someone turning up with their evidence. I mean, and that, you know, despite the fact you ask for anything to be sent in advance, particularly in a more complicated case, people do turn up with stuff. And I know before that we've said, look, we simply can't just sit here and get our head around that. But it's fair, and there again you're faced with a slight dilemma, because do you say, if someone turns up with a great big 3 inches of evidence and sticks it on the table in front of you, your choice is to say, I'm sorry, you had your opportunity to send that in advance, therefore we're going to ignore it and carry on? Or do you say, you should really have told us about that in advance, nevertheless we're going to postpone the meeting, and because the fairest thing to do would be for us to look at that evidence? And I have generally come down on the side of, let's deal with this evidence now, because if you don't do it, as in postpone the meeting, get our heads around it and then come back together.
Yeah. Because
if you don't do that, it's inevitably going to have to be dealt with at appeal. Someone will end up having to deal with it at some point, and if it does contain anything that changes changes your view, or that alters the course of, you know, the disciplinary, then it's better to know about it now than later. You know,
it always shoots you in the foot if you say, no, I'm not going to take account of that, or you had your chance, you can't present that now, it comes back to bite you.
Yeah, and don't forget, you know, everything, the other thing that always goes through your head is act reasonably. You know, to anyone looking in on this process, will they look at it and say, did I act reasonably or not? And ultimately that's what a tribunal is going to do if it gets tested there. And so that's always, I think, particularly in dismissal cases where there is more potential for it to become a claim, you know.
The other thing I'd say there, Ed, just to chip in a bit, you know, we're talking about escalating and ending up in front of a tribunal judge, which nobody ever wants to do. But there is the other thing that we'll talk about appeals later. But, you know, as a manager making really important decisions like this, if the employee then appeals against the decision and against what you did, it's going to end up on your manager's desk. Now, that ends up being a really uncomfortable situation, because, you know, your manager will then question what you did. And, you know, you're not going to look great, because they've now ended up with this issue that they wouldn't have wanted to deal with, and they're not going to really feel that you've handled it very well. That's pretty uncomfortable. And in a situation where, you know, a manager thinks, oh no, I'm going to have to overturn the decision of one of my team members, I mean, that's really uncomfortable for everybody.
We've got a hand up.
I'm going to bring in Andrea, who's raised her hand. Hello, Andrea.
Hi, Andrea.
Oh, asked to unmute. Can you unmute, Andrea? Yeah.
Is that better?
So just for everyone's benefit, Andrea is an employment lawyer, a very close friend of ours who we've worked with on many cases over the years.
Some very interesting ones.
Yes, indeed. We've got a few scars.
Indeed. Just one point, because it's an interesting one about somebody pitching up with new information, new evidence, suddenly throwing it in the mix at the 11th hour when you're actually trying to progress the hearing. I think you've got to be wary, particularly with difficult individuals, shall we say, of them trying to muddy the waters or indeed introduce an unrelated matter. So I think it's quite useful to try and establish whether what they are introducing is actually related to the issue in question that's being dealt with in the disciplinary, or whether they might actually be raising a grievance about something that is unrelated.
Right.
Because you can deal with the grievance separately and concurrently with the disciplinary if you need to. So I have had scenarios where that's happened, and they've said, oh, well, what you don't know about is, you know, this manager's done X, Y, and Z in relation to me. Well, yes, it might well be something that you need to look into, but it doesn't necessarily need to derail the whole hearing and the whole process if actually it doesn't impact on the matter that's being considered on the day. So it's just worth bearing that in mind, I think.
Yeah, great.
Good point.
Great point. Thanks, Andrea.
Yeah.
And we're going to come back to Andrea in a little while, because as we go through the chronological order of things, obviously one or two things end up in tribunal, and so Andrea's going to come back and give us a couple of reflections on that towards the end of our session. So thanks for that, Andrea. Okay, so with that, we talked about postponing. Another thing I would say is use adjournments in the disciplinary meeting as well. So, and that can be for a whole variety of reasons. It might be that the person that you're dealing with needs a break. They become a bit emotional or a bit confused, or they and their companion need to have a bit of time out in order to get their head together and work things out. Sometimes if you're on the disciplinary panel, sometimes you want to take a bit of time out. It might be that you want to just check that you've asked everything that you want to ask, reflect on what you've heard and think about, is there anything else that we need to know? You know, so, but don't be shy, you know, use that, you know, or if you're just under a lot of pressure, take the opportunity of a postponement, or sorry, an adjournment. So where you literally just, you know, leave the room for a few minutes, or they leave the room for a few minutes, and then take a break and then come back together, together again. That happens a lot, particularly in difficult cases. I mean, Andrea mentioned there that, you know, people can bring evidence that may or may not be relevant. Sometimes, you know, sometimes people go sick before a disciplinary hearing. And of course, that may be genuine or otherwise. It might be a ploy, it might be genuine. The point is that it's, you know, you need to judge each situation as it arises, to look at all of the circumstances. You know, it may be that there's a history of illness, that so it kind of makes sense. It may be that it's very out of character. It's like, you know, that there are any number of different scenarios to take account of, but what you need to do, remember that act reasonably thing, and look at the situation and decide what you think the best thing to do is. Now, ordinarily, what that might look like is you postpone the meeting for a period of time, but depending on your read of the situation and what you can find out about the nature of the sickness, someone going sick doesn't mean to say that you have to shelve your case until they come back. You know, there are circumstances where you might decide to carry on, give them the opportunity to attend a meeting or to deal with it remotely or something else, but that actually you are going to continue with the case. I would say seek advice, because they're very individual situations. And obviously, you know, you're under a lot of pressure at that point in terms of wanting to force the completion of a process in circumstances where someone's saying they're unwell. So that's always a tricky one, and a delicate one to decide. But it doesn't automatically mean, as I say, that you just have to wait for an indeterminate amount of time in order to complete the process.
Yeah.
We've had a question come in relating to witnesses.
Yes.
So the question is, if no witnesses are willing to make a statement unless it is anonymous, will this be acceptable?
Very good question. Very good question. And I think I know that certainly in cases that I've run in the past, we have anonymized witnesses if they felt that that there was some a reasonable prospect of them suffering some kind of comeback, but they were willing to testify. I mean, obviously that can create difficulties with the other side, you know, with the person accused. It also creates difficulties if you want to be able to question that evidence in the disciplinary hearing. You ideally want people who are going to be able to come and answer those questions and be asked questions by by the person who's accused of the disciplinary event. So again, it is another sensitive one, but I've certainly been in situations where sometimes you feel it's better on balance to take anonymous evidence and present it on the basis that it is anonymous, but it's worth hearing, than not. You've got to kind of balance the the kind of protection of a witness with the importance of what they might be saying. It's difficult, you know. Karen, do you have any
well, funnily enough, I got asked this
around that?
a couple of weeks ago, but it actually was a little bit more difficult than that, because the team was so small that it wasn't a question of, you know, where you've got a reasonable sized team and someone's prepared to make a complaint that they'll keep it anonymous because the person won't necessarily know who it is. That's one situation. And in answer to the question, yes, it may be possible to pursue the disciplinary with that person remaining anonymous. But the question I was asked was, the team's too small, so they won't be anonymous. Just not putting their name on it, you know, there's only two of them.
Yeah.
Now, you know, that was a very difficult situation. Now, in the end, they did go ahead, and the way that they approached, because you've got to balance it with the whole principle of you know, fairness and the principles of justice that you were talking about at the beginning, Ed. Somebody facing a disciplinary or facing the loss of their job does need to know what they're accused of and who accused them. But equally, we have situations in the workplace where we need to protect other employees. So is that going to be easy? No, that is going to be really tricky. But there may be a situation that the client I was talking to was in, where essentially the manager had to take responsibility. So they had to say, I have had a report, and I have taken every step to verify and to you know, give myself the confidence that that report is given in, you know, it's not given with malice, it's accurate, it's as far, you know, it's truthful, and I'm going to relay those circumstances to you without saying where that came from or who said it. And they then did manage to make the employee aware of the concerns. But yeah, that was really difficult. Yeah. Another scenario, I've had a situation where the employee wanted to remain anonymous, but when the manager really dug down into it to get to really know whether he trusted that report and was prepared to act on it, he found all sorts of relationship issues between the two of them. And actually, he thought it was a bit vindictive. And that was the opposite. He didn't feel confident to act on the report. He thought there was some payback coming into that scenario, and he had to tackle that a whole different way. So yeah, it is difficult.
It is difficult, yeah. But I think it's like, you know, try and balance, you know, the need for a fair process for the person accused on one hand, with the need for kind of to be able, you can't ultimately compel people to give evidence and attend a hearing. It's not a court of law. So you know, you've got to act reasonably on all sides and try to find you know, and if you've got a reasonable rationale for the way in which you handled it, you know, if you're happy to stand by it, then go ahead and stand by it, you know.
Yeah. Ed, we better catch up a little bit now.
I know, yes. Yeah. So yeah, so we were doing a kind of any other what not to do's on the hearing itself. Yes, don't deny people a companion. That's an absolute right that they've got. We've talked a bit about the different scenarios that can occur there. Don't ignore evidence. Kind of goes without saying. Make sure you've got evidence to support what it is that you're accusing them of. I think we've talked about that. And as Karen said, don't make an instant decision. It's really important that your meeting isn't or doesn't a sham. In other words, you know, it's a show trial for you to tick a box in order to give a penalty. So you know, and that's why I say have clear distinctions between, you know, there's an investigation, there's an invitation to a meeting, there's a meeting at which you discuss all the evidence and ask what can be some quite hard questions, and then there's a decision, you know, just to divide it all up, as Karen said.
Yeah.
So then we come to the decision itself, and obviously you need to make a reasonable decision in all the circumstances. So it's important that you've got a rationale, you know, and that you note down your rationale for the decision that you make, and that's very important. It needs to be reasonable in the circumstance, obviously. Now the outcomes can be that there's no action at all. You find actually there's not really any case to answer, having looked at it all, or it might be that there's a warning of some sort, or dismissal. Now check your code of conduct in terms of what it allows you to do by way of disciplinary penalties. I've had it often where you get to the end of a process and someone says, well, I want to suspend them, I want to demote them, I want to do all of these things. Well, it's not in your, you know, it's not in your disciplinary code, and they might not be in your disciplinary code for good reason, because things like reducing people's pay and things like that are often a very, very difficult things to do. But what there will be in your code are a series of warnings set out with around certain parameters. So you do need to impose a penalty that's in line with your code of conduct. If it's a written warning, so I imagine that in most cases it's some kind of written warning is given, and in which case, you know, make sure that there's it's a clear outcome stated in the letter. With, if there's improvement required, be very clear what that improvement needs to be, provide a timescale for that improvement, and also the consequences of not improving or repeating the behaviour in terms of a further disciplinary penalty, possibly dismissal, whatever. So tell people what potential consequences might be of any further similar behaviour. Make sure you put a date on the letter, which sounds like an obvious thing to do, but you'll be surprised how many letters we find in files without dates on, which doesn't help when you're going back and looking at whether people have had previous warnings, because there will then be a time given for how long that warning remains kind of live, and you can go back and rely on it if there's a repeat. So little details to make sure you pay attention to. Now, of course, if it's a dismissal situation, there are two types. There's a summary dismissal for matters of gross misconduct. So that's obviously where something that's so damaging has happened that it could render an instant or a dismissal for a first offence as a reasonable outcome, or it could be what we call a normal dismissal, which is more likely to happen where there's been a series of warnings and a series of incidents that have led up to a point where you just, you can't can't continue with those situations repeating. So again, if you get to that point of a dismissal, be very clear about things like what the notice arrangements are. So in a summary dismissal, for example, there's no notice given and provided. Where there is notice given, be clear how you're dealing with it in terms of, pay in lieu of notice, or, it's slightly unusual to people to work their notice if they've been dismissed. So they would be invariably paid in lieu. So again, details to attend to in any of those scenarios. The thing about, I would say, if you're in a potential dismissal situation, you do need to have identified the potential for that early on in the process, because actually in the letter that you write to people to invite them to a meeting, you invariably set out what the potential consequences might be. Mm-hmm. And if you think it could be a dismissal or a summary dismissal, it's important that you state that that's a potential outcome when you invite someone to their disciplinary meeting. Okay, I'm very aware of the time. Karen, have you got any kind of final tips on that before we bring Andrea back? Because I think it'd be very interesting to hear.
I want to hand over to Andrea. You're right. I'm going to say a couple of very quick things. One, the employee will have a right of appeal.
Of course.
That be in the letter. We won't go into a lot of details now. As I say, we're talking about employees with 2 years of service, so they will have a right of appeal. You do need that in there. Please make sure you actually give them the letter, and that you've got some record of that. I've been in circumstances where we'll write the letter first and actually issue it and date it, and then make sure you actually give it to the employee and you've got a record of that, and then you keep it on the file. All of those things sound really simple, and all of them don't happen on a regular basis. So I think I'll just leave it at that.
So Andrea, if you can unmute yourself again, because obviously a lot of the things that we think about when we're going through, particularly the more contentious disciplinary matters that we're helping people with, what we've always got in our head is, how would this play out at a tribunal? And that's what guides us often in the advice that we give. So so obviously some cases do end up in the tribunal. So I thought it'd be really interesting to hear what some of the kind of classic typical things that tribunals really don't like, that we should really avoid like the plague.
So I mean, a tribunal, when they're coming at an unfair dismissal, a dismissal on misconduct grounds, which is what we're looking at here, they are looking at two elements. They're looking at the procedure and whether there have been procedural failings, and also was it a reasonable decision. And so even if it was very cut and dried, unfair, very cut and dried summary dismissal, or gross misconduct, hands in the till type scenario, if there was no procedure followed, there may well be a finding of unfair dismissal. Yes, there may be limited or no compensation, because they will look at whether actually a procedure would have made any difference to the outcome or not. So looking at the question of loss is another matter, but actually it could still be an unfair dismissal decision. So it is important to bear that in mind, and to really follow procedure, even when you say, well, it is so cut and dried. I caught them, actually with their hands in the till, and they're out the door. Yes, but you still need to go through a process with them. You may well suspend. I would say that tribunals do not like suspensions for the hell of it. They really don't. So unless you really need to keep that individual off site or deny access or whatever it might be, just think about whether you do need to suspend them. Obviously, you should be paying them, and make it clear that it's not a judgment as to what the outcome of the disciplinary will be, because it does lend itself to it looking like a preordained decision if you are suspending when there really isn't a basis for doing so. Just looking at procedures, and obviously we talked about the fact that you should have contracts and you should have disciplinary procedures in place. Not everybody does. Make those procedures non-contractual, so you do have some wiggle room, because yes, there is the ACAS code that is guidance and should be followed in the absence of a procedure. But if you have a procedure that is part and parcel of an employment contract, then you know, any little steer away from what your procedure actually says potentially is a breach of contract and a breach of procedure. And you don't need to put yourself in that situation. Sometimes you may need to deviate from a certain step. It is your process to follow as you see fit. It is not something where you want to be dictated word by a process and a procedure that you put in place possibly some time ago, or somebody did put in place without these particular set of circumstances in mind. So that is important. If it's a gross misconduct situation, if it's very serious and you're effectively jumping all the steps and going straight to a summary dismissal without any notice, you know, that should be a pretty cut and dried situation. Yes, you may well, because it's so serious, need to have a detailed investigation and a full hearing. But if there is, and I've had a situation where an appeal have gone on and on and on for weeks and months on a gross misconduct situation, it does lend a question as to, if it was such a serious matter and a proper process was followed in the first place, why is an appeal taking so long? Why are further inquiries and investigations having to be made? That should be dealt with in the first place. And actually what you should be doing is, in the absence of anything new and pertinent, just confirming that yes, this was a sound and valid and reasonable decision, and we're just confirming that that decision stands. And something else I just wanted to look at, you know, do stand by your processes and your decisions. A tribunal will, yes, look at whether it was a perverse decision, whether the process was reasonable, but they will not want to completely unpick a dismissal decision unless there really is a valid basis for doing so. So, and when you are going through a process, just think, actually, if I had to stand and, you know, read a statement out saying this is what I did and this is why I did it, and it was a fair and reasonable outcome, then you are able to do that and have strength in your convictions and confidence in your decision, and make sure that whoever's dealing with the stages of the process does have the confidence and the training to follow, to do what needs doing and to ask the questions and to make the decisions. Not everybody finds, however senior in an organisation they are, not everybody finds those meetings and those decisions easy. Nobody enjoys them. If you need to involve somebody like Ed or Karen as an external person to come in and assist or deal with an appeal stage, perhaps you're a small outfit and you don't have somebody, another person, because you wouldn't want the person making the original decision to be dealing with and hearing the appeal, then get somebody else in to do that. I know Ed and Karen would be happy to do so and often do assist in that situation. And that can help to give confidence in your decision and your processes as well. Finally, if it does go sour, if it's clear that the decision is challenged beyond appeal, the individual would need to go through what's called ACAS early conciliation before it goes to a tribunal. So they would need to be effectively saying, I'm going to be challenging this, I'm looking at taking this further by way of a tribunal claim. Before they do so, ACAS would contact the employer, contact yourselves and say, this employee or ex-employee is looking to raise a claim, this is what they're saying, and they will try and conciliate. And often, obviously, it'll be a financial settlement, but that's what they will be looking to do. If that cannot be, if matters can't be dealt with, then ACAS will issue a certificate, say we've not managed to resolve matters, and then it's up to the individual whether they take it further by way of a claim. So it's not necessarily the case that, you know, the appeal is confirmed and then the next thing you know, you've got a tribunal claim. You would hear from ACAS, or should do, as a next step. You can also consider whether there is an exit payment in the offing. Not saying you're going to do that if you think there's valid reasons for a dismissal. But if matters go a certain way, then you may well have what's called a without prejudice discussion. And that's something that can run concurrent with a process. But obviously, you don't want to be making the whole process look like a sham, or look like you are questioning what the decision's going to be. If you have any discussions off the record, as it were, that needs to be kept separate, very much so. It needs to be clear that it's without prejudice, it's off the record, it's separate to any decision, it's not part of any evidence. Right, I shall leave it there unless anybody has specific questions.
Yeah, thanks, Andrea. I was going to just ask the question we had about anonymity of witnesses. Did you have anything to add to that?
Only to say that from a tribunal's perspective, obviously, if somebody's not putting their name to the evidence, the question arises as to why that is the case. It is always better to have somebody who is willing to put their name to the evidence and to, if necessary, give a witness statement and be questioned on that, whether it's at the meeting itself or subsequently at a tribunal hearing. But there certainly, as you've made it clear, are circumstances where, for whatever reason, you can't force somebody to sign off a statement and put their name to it if they're not comfortable in doing so. But I would ask the question of them. I wouldn't just assume that, okay, we'll have to make it anonymous because they're saying that they're not comfortable. I'd be saying to them, look, why are you not comfortable? And, what is it that you're willing to say to put your name to? And, can we alleviate your concerns, or can we just talk it through? Sometimes it's that the automatic reaction is, no, I can't possibly, put my name to it. But actually, they are merely confirming often just factual information, and it may well be that others are doing the same, and they don't need to be concerned about that.
Yeah, absolutely. Thanks, Andrea.
Thanks. Yeah, thanks, Andrea. And that wraps things up very nicely. Thank you, everyone, for attending. It's been, it's been a blast. it's been, we've enjoyed putting it together. I have to say, I hope you've got some value out of it. As I say, it's the first in a series. All the details are within the community hub. We'll be advertising them as well on a regular basis. We're doing basically one of these a month. But we will intersperse it with topical issues as they come up. And please, a request, if we want to make it relevant, so if there are topics people would like us to cover, including bringing in people like Andrea and others who we know who are expert on to certain topics, then that's certainly what we will do. So please let us know. We want to make it relevant, yeah, that's what we shall do going forward. So thank you ever so much, everyone, for coming. Have a good day, and hopefully we will see you next month.